All right.
Are we good, Trace, or do you want to give it a minute?
No, I think we're good. We've got majority here, so we're ready to go.
Perfect. Great. All right. Well, good morning, everybody. Welcome. Good to see you all. It's oh my gosh, mid-October. And do you understand this is our second to our last meeting? It's incredible. 2 years ago, we started on this journey together, everybody. So thank you for hanging in there and for being with us today. I'm going to go ahead and start off with just some meeting minutes. We need some approvals. And so you received the August 7th meeting minutes and the August 7th meeting summary in your email for preparation for today. As it relates to the meeting minutes, are there any additions or corrections that folks need to have made to those meeting minutes? Seeing no hands. All right, let's go ahead. If we could have a motion and a second to approve these meeting minutes, please.
This is Zane. I move to approve.
And I'll second.
Okay, so we've got Zane as our motion, Kathy is our second. Is there anybody who is opposed to the approval of the meeting minutes from August 7th of 2024? All right, seeing none, thank you. And thank you, Margaret. We have you down as an abstention. Appreciate it. Moving to the meeting recap, also of August 7th of 2024. Are there any additions, corrections, changes that need to be made to this document? And I'm scanning the screen. I see no hands raised, no red markers. All right. If we could also have a motion and a second to approve the meeting recap.
Apologies, I didn't mean to raise my hand.
Okay, I was just like, I see a hand. All right. A motion and a second, please.
I'll make the motion. This is Kathy.
Thanks, Kathy.
I can second. This is Ida.
Thank you, Ida. We have a second. And is there anybody who is opposed to the approval of this meeting recap from August 7th?
I will abstain. This is Leanna. I was not present at that meeting.
Great. Thanks, Leanna. We'll mark that down. All right. I see no hands in opposition to the approval of these minutes, so they will pass. I'm sorry, not minutes, meeting recap. We're approved. Ready to go, Trace.
Perfect. Margaret, thanks. I see the abstention for you and Kelsey in the chat. All right. Good morning, y'all. Thanks for being here. We've got 2 hours today, and I'm sure plenty of discussion ahead of us. So I'm going to jump right in. You received in your email the remaining recommendations as written. I want to flag a couple of things. We're going to actually start with 16 through 19. Then we're going to take a quick break because there is a little bit of a mix-up of what belongs where on 7 and 11. And so we need to go back to the drawing board real quick because I want to just make sure that we're not confusing folks on how we are talking about them. It'll still be the same content, but when we reviewed that this morning, we realized there were a couple of things just kind of we needed to move around. So I dropped in the remaining recommendations document. This is the one that you received in your email. If you could go ahead and skip over 7 and 11 and go straight to recommendation 16. We'll do 16 through 19 with Doris, and then we will take a quick break so that we can kind of make sure we're all on the same page with 7 and 11. We'll come back and share a different document, and that'll be the document we're reviewing. And then that'll be the end of the meeting. All right. Okay, cool. So that's the any issues accessing the document I dropped in? Okay, perfect. So grab that and I will hand it over to you, Doris.
Awesome. Thank you, Trace. Good morning, everyone. I just put in the chat following the link to the document itself, our prompt questions so that as you're rereading the recommendations, you can have those prompts kind of in mind, jot down any commentary related to them. Why don't we take 15 minutes and go through all 4 of those directives, and then we will pause and have a conversation using these prompts. So we're going to try to get through all of them in one read, and then we'll take them one by one. All right, so my clock says 8:07, whatever. What is 15 minutes after 8:07? 7.
Let's do 8:25. We'll give them a couple extra minutes.
Perfect.
8:25. All right. Thanks, y'all.
For those of you who just joined, we are reviewing the documents in the drive. We're going through directives 6 through 19. Hold on, I'm gonna put the link in the chat. And it didn't copy and paste the right thing. Hold on. Lord.
I can do it. I got you.
Oh, thank you. Yeah, it didn't paste it.
I believe it's 16.
Did I not say 16 to 19?
Yeah, you said 6, I think.
Oh, I'm sorry.
Yeah. 16 to 19. Zane, did you have a question?
No, I have a comment once we get started.
Oh, okay. Okay.
And then I just popped in the prompts as you review the directives. These are the 3 questions we want you to be thinking about. We have about 5 more minutes. All right. Does anyone need more time? All right, so we're going to start with Directive 16, since I said six last time, which speaks to the personal information of a child that is collected for a report. And I'll just go ahead and open the floor, and I'll start with Zane. You're muted, Zane.
I actually unmuted myself and then muted myself. That's how my morning's going. So on 16B, the first bullet says that the oral reporting requirement mentioned be removed. But then in the paragraph below, it's removing the written report. So I was kind of confused by that. I'm not sure. I don't know what I missed there. So that's question number one. So I just wanted to clarify that we meant oral and not written. Secondly, I don't recall the conversation about removing the written report, because then I guess my question is down below when we start talking about online reporting, that seems like that could constitute a written report. And wouldn't that just contradict what we're trying to do with allowing people to report in writing? And then the third thing I wanted to mention is about the Trails system, that individuals entering information in Trails about a report of child abuse and or neglect are required to ask reporters about any family strengths, such as parental involvement in school activities. So are we proposing then the online system would give the option for people to enter that information should they know it? And a lot of calls that come in, I mean, I've called myself, I don't know the family, I've just witnessed something and I have a license plate number in their description, and that's about all I have. So I want to make sure that if we do have like a online reporting system, that there's not, required fields that me as the reporter may not have information and cannot proceed without, having that information, if I'm making sense. So those are my three things about 16 that I was concerned about.
Thank you. And I think that was a good catch. I remember the conversation where we were talking about the written reporting requirement. And that was, I think, basically aligning the statute with what actually happens in practice. And when folks make an oral report, they don't then follow with a written report. And so I do think that is a typo, but invite other folks who were part of that subcommittee to chime in and correct me if I'm misremembering. Michelle, I saw you nodding, so I think that you were part of that conversation.
Yeah, we did talk about the need to remove the current statute language that says they're required to make an oral report followed by a written report because it's so duplicative. I think simply that we could, to address Zane's concerns, is we could simply just say when making an oral report, a written report is no longer required, or I'm not language ready yet, but something like that just alleviates that responsibility, but doesn't then stomp on the issue around those making a written report. I mean, like an online report.
Yeah, thank you, Michelle. All right, so we have several hands up. I'm going to take Donna and then Jessica.
Mine's is quick. Because race and ethnicity is not the same, we need to add race under A. These include race/ethnicity, language, gender expression, disability, etc. Race is missing.
Thank you, Donna. Jessica?
Thanks. So yeah, mine was kind of along the lines of Zane. I do remember talking about that. I will point out that I've had multiple people come to me since we had this discussion meeting. And I know it's a little out of turn, but having big concerns about taking out the requirement. And I know this is substance, but I've had multiple, I think people honestly, without getting into things that can't be really talked about publicly, but multiple issues concerning, well, I thought I made an oral report and then it was never followed up on, so I guess it wasn't dealt with, right? And then kind of getting into sticky water legally with whether or not they had complied with their obligation. So I want to point that out. I know this is substantive and not about the three kind of directives we have, but I just feel it's imperative to point that out because I think that it's potentially putting some more liability around mandatory reporters and increasing their liability. I see Adriana shaking her head, so I'm going to call her out on that. Increasing their liability by not having the follow-up. I agree. Like, I think in our discussion, we were like, well, it's not really the practice. And unfortunately, I think it comes from that, you know, you expect that then the law enforcement or DHS is going to file or follow up with an investigation. And then in certain cases with certain issues, they're not. And then there's an issue of that it was never reported or was it properly reported. So I just want to point that out. Sorry to throw a bomb in there. And the other part is that, so I guess I'm advocating that we leave it the way it is. I know it's not consistently practiced, but I do think it creates that liability. The second part is that we did discuss in the meeting, and I think we all had agreed upon, was that removing, and this is also in subsection B of Directive 16, removing the portion in 19.3.307.4, which talks about that a written report shall be admissible to in evidence, regardless of where we decide on written reports. That shouldn't be removed. We all discussed that, and I thought we had come to consensus on it, so I was surprised to see it here because and we talked about it's a little bit confusing. We thought, okay, I think the original intent was if we are removing the written report piece, then we need to remove this other paragraph. But that other paragraph, I think it was a matter of grammar. It reads, a written report from persons or officials required by this part, so to report. So a written report by mandatory reporters shall be admissible into evidence, right? And we discussed, well, okay, that doesn't mean it's not another portion of the statute that says a written report is required. It's a written report that is required or by people that are required to report. It's just a stupid way of saying mandatory reporters who make written reports, those written reports are admissible into evidence. And I had a big objection to that. And I don't remember if Kevin, we had talked, you had jumped in on that or Adriana at all, but that's really going outside of the directive into what's admissible into evidence in court. And when we do have a written statement by a mandatory reporter about what happened, that's oftentimes going to be admissible in evidence under hearsay rules. I see Kevin and Adriana shaking their heads, yes. And this portion reinforces that any written report really is admissible in evidence so long as under 19.1.307 it's admissible. So I just want to really advocate to remove that portion entirely, regardless, that recommendation piece entirely, regardless of where we go with the written or oral piece. I hope that makes sense.
Yeah, so just to clarify, the sub-bullet, the second sub-bullet here, you don't want this to be a recommendation at all.
Correct, because
Yeah, I was just because it's what the way that the recommendation is written right now. It's this bullet shall be removed. Like this language in the statute shall be removed. I'm saying it a different way so that we're not using the removed language again. So just strike this part as a recommendation.
Yeah, I think it was just unintended because it's written in kind of a funky way. I think to be clear with our recommendation, if we are saying, let's remove the written report, then I think we could clarify in that second paragraph, any, written report, while not required you could just call it mandatory reporters, but that could become in drafting later, from persons or officials required to report shall be admissible. If that kind of clarifies, right, that it's not required, but that it will still be admissible if it's done.
Thank you, Jessica. And so Margaret and the person, I'm sorry, I don't know who it is, who has CCASA staff. I'm going to call on you in just a moment because I think Ashley and Michelle want to chime in on this particular point. And so I'm going to come back to the two of you. Ashley and then Michelle.
Yeah, thank you. Well, I'm just looking at what was in the chat about that oral reports are tracked, they're recorded, so there is sort of a documentation of it. I'm wondering if I'm wondering why in 19.3.3074 only written reports are admissible and not like the recorded report. So I'm wondering, I mean, that seems like something that should also be admissible. I'm wondering if you could keep the language in subsection 4, but just strike the word written, and then both of those sections would be consistent and you would still have admissibility of the type of reports that are actually happening. I'm just curious why it has to be written. That seems honestly a bit outdated.
I'll just back that, what I was gonna say is similar to that. So yes, all the calls are recorded from the time the phone rings to the time the phone hangs up, and it has been used in court, because I've been a part of testimony where the recorded call has been replayed in court. So I do think, and the statewide hotline and the recording all came about long before or long after the statute was developed. So I agree with Ashley that we could just modify it that all recordings and any written documents associated to the report could be used as evidence. And we left the bullet in around the written report, that second bullet, we left that in because we did not want people making an online report and being excused from anything that they document being used against them. Like if it was a false report, for example, that we said that we would say that in the online reporting platform, that you're making a legal document that can and will be used against you in a court of law, something like that, right? Like if you make a false report, that document can be used. So we wanted to preserve the written wording for that, which is why we left that in there.
Thank you, Michelle. Michelle M, did you want to chime in on this same point?
Yeah, Jessica and I have talked about this in a different context. I guess what we're doing is basically clarifying something that I thought to be the case and I guess isn't, that the identity of the reporter is not confidential. Like I used to train on that, but that's clearly not at all the case, correct? And Jessica's nodding her head, and that's seems to be consistent with the intent of this group, that it remain sort of out there and that they could be called into court.
The identity already remains.
So I will say,
unless the court orders us to release it.
Say that again, Michelle, I'm sorry?
The identity of the reporting party remains confidential unless the court orders us to release it.
But the report is used as evidence.
Is the asterisk.
But it gets sanitized out when it's turned over to the court. The reporting party information gets blocked.
But not in criminal cases, it doesn't.
Okay, but okay.
I was about to say, there's going to be a difference. If it gets called in criminal, then yes. I still move, regardless of it, for court orders to release that information and try to make good faith arguments that a reporting party is entitled to protections. But by and large, if we need the report, that information.
In the criminal context, Adriana, you do that?
Yeah, I do primarily civil. And so civil, I'm
Okay.
given a lot more grace and leniency.
Yeah.
It's rare, but if I have to use that report, then I ask the court for an order to release that reporting party information.
That's helpful. And Jessica helped me understand in the criminal context why that is so different. That's helpful. Okay, thanks.
Thank you, Michelle. All right, Margaret. And then Gina, thank you for updating your name label.
I just wanted to give anybody else an opportunity to weigh in on that, on point B, on that subpart B before I comment, because my comments are on C and D.
All right, Kevin, I see your hand came up. Related to this topic, B?
Just real quick, I think it has been said well already, but I agree with Ashley and Jessica both that in the criminal context, that information has to be admissible.
Thank you, Kevin. Sam, did you have a comment on B?
Yeah, and I apologize if maybe I missed the wider conversation, but I guess I'm concerned if we're putting that mandatory reporter's information into evidence when part of our conversation is that those who report tend to use language and describe situations in a particular way that includes bias. So I don't know the bigger conversation, I don't recall it, but I'm kind of concerned with that's a key part that we're including, if that information then includes substantial bias, even if in the end it's founded. Just some of the ways that people talk about families in and of themselves make a situation seem different than a straightforward, I saw this CPS or DHS investigation might show.
Yeah. Okay, thank you, Sam. That wasn't the wider part of this conversation. I think we were, when we talked about this particular directive, we were narrowly focused on what information gets gathered or collected as part of a report, and then also refining some of the language so that it is consistent to what happens in practice. So A is about adding some additional characteristics. B is about really clarifying this current requirement of following an oral report with a written report, and recognizing that in most instances, a written report doesn't follow an oral report. So striking that part of the language, and then allowing for an opportunity, I think, which gets closer to your point, Sam, at least for some of the information that gets collected, for the family to correct the record. So as it relates to demographic information, a reporter may not actually know and may be guessing about some of the demographic characteristics. So allowing the family to correct that information. And then subpart D is about ensuring that when the information is entered into trails, so information is getting collected to be entered into trails, there is an opportunity to sort of counterbalance what might be received by a reporter with gathering information related to family strength. So not solely focused on, some of the things that are of note related to potential child abuse or neglect, but also entering in the conversation, family strength. So I hope I didn't, again, muck up the conversation and sort of remembering back. But I think that was just a broader context in which we talked about this particular directive. All right, Margaret and then Gina.
And Gina, I just want to make sure that you don't have a comment about this before I go galloping off into C&D.
No, my problem is with A.
Do you want to hit that one since we're kind of going in chron order here?
Sure. So thanks, Margaret. My issue is around when available. I think we talked about this before. I'm concerned about reporters and turning into investigators, questioning a kiddo about these characteristics and what kind of experience that might be for the kiddo. Like, what does that have to do with anything? Am I going to reveal something about my family makeup that might potentially get me into trouble, or are we in trouble because of my family makeup or my identities? So I would prefer, instead of when available, something like from prior knowledge or experience versus potential like interview happening / interrogation. And then for gender expression, I think gender identity would be a better change out, and then including or adding pronouns.
Thank you, Gina.
That's it for me.
Awesome, thank you. Thanks. Margaret?
Thanks, Doris. So I'm walking that fine line between a drafter's nightmare and providing more guidance. And I recognize that. So just want to offer under subsection C, families be given the opportunity to confirm or correct the demographic information. I would love to see some clarity there, that there be given a charge to the department to, within X number of days of contacting the caregivers, the department shall have X number of days to correct the information on receipt of the family's input with respect to these concerns. Otherwise, I kind of feel like it's just hanging out there without any real guidance as to what we're doing and when. And I also think that state departments are pretty accustomed to being given deadlines within which to act. Otherwise, I feel like, well, we were going to get around to that. Then under subsection D, similarly, that fine line, I love that parental involvement in school activities is given as an example for training for operators on the hotline. I think that we could make suggestions for other types of family strengths, like extended family support, evidence of medical care, those kinds of things that are indeed protective factors, but help train the operators to think broadly about what those strengths might be.
Awesome. Thank you, Margaret. Any other considerations for Directive 16?
I have just one, or two, I'm sorry. One is, I think we should add the word primary or primary spoken to the word language, rather than just the word language, only because I think it helps DHS know which language the family's preferences to be communicated in or with. I don't know if anybody else agrees with that. If nobody else does, that's fine too. I just think that just language is too benign.
Thank you, Michelle.
And then for C, I'm also wondering about, I just want to highlight what Yolanda had said and wanted to emphasize that for families on screened out referrals, they wouldn't be given the opportunity to correct information. And 60-70% of the referrals we receive are screened out. So I don't know if that means we need to make some additional or put some additional words in for maybe the families upon assessment would be given that opportunity, because they would not be given that opportunity on a screened out referral.
Awesome. Thank you, Michelle. Sam and then Jennifer.
We had talked about, my comment is referring to D and that asking about family strengths. We also had an extensive conversation of, did you speak with the family at all? So asking that question of, have you stated your concerns to the family? And that just being a yes or no, I think that will be important data for us to have ongoing.
Awesome. Thank you. And Jennifer, you look like you're in a different space. You're muted.
I am in a different space. I'm on a different computer. I'm having all sorts of difficulties this morning.
But we appreciate you joining anyway.
Well, I'm happy I could make it. Thanks. Yeah, I had just a couple of things. First on C, the confirm or correct just seems like a little awkward to me. I thought maybe we could do review and correct or review and edit, just to make that a little easier to read. Confirm sounds a little directive in terms of like, just tell us we got it right. And then and on D, and I've been interested to hear everyone else's conversation about why this piece about strengths is here. And I get it. I just worry a little bit that feels like digging into an investigative role for the reporter. And so I would want to make sure that that's worded in a way that does not suggest that the reporter must ask follow-up questions, get, additional information, and is put in more of an investigative role.
Thank you. Thank you, Jen. So just to clarify, dot point D speaks to the person receiving the report and ensuring that there are lines of question that are designed to tease out any family strengths. So it's from the recipient of the report and sort of like the questions that they ask the reporter to try to tease out that information.
So I think in that case, which yes, I do read it that way, we want to make sure that in the training then, of course, that it's clear to mandatory reporters that even though they'll be asked those questions, that's not information they're required to illicit.
Got it. Thank you, Jen. Michelle?
I was just gonna try to provide a little bit of clarity. First of all, as a part of enhanced screening in Colorado, these are questions that we are already asking as a part of hotline calls to elicit information about what also is going well for the family, what are their strengths, what are their resources to help balance out the information. But it also helps the department determine if, for instance, we were going to provide alternative resources or preventative services, what the family may or may not need, or what they may already have in place, or what we can build upon that is already a strength. So I think it's a both and I don't think it's investigatory to ask them, do you have other additional information outside of this one incident that you're reporting to help balance out the totality? Because we don't want families just being defined by the one incident of physical abuse that they're being reported, but there's so much more to families. So when we get that additional information, it helps us make better decisions. It helps us better highlight what's available for the family. And often, if you think about, for example, schools making reports, they hold a ton of information because they're with kids all day, every day. So if a reporting party, like if an officer calls, the officer is not probably going to have any additional information. If they do, great, but schools are. And so we want we want an opportunity to be able to ask that question and elicit other information about the family other than the incident.
Thank you, Michelle. All right, I want to move us along. Oh, sorry, Stephanie, I see your hand up.
Yeah, thanks. I just wanted to follow up, Michelle, with two things that you said. One is, did you say that those questions that are already being asked about family strengths or resources is already part of enhanced screening or just general screening for all human service departments?
All counties are required to conduct enhanced screening, and there is a tool that is provided to us to help ask or get information, including the strengths of families.
Great, thanks, Michelle. And so Doris, one of the questions I would have to this group would be, then do we need subsection D? I mean, the answer may be yes, right? That it's good that human service departments are doing this, but if it's not in law, maybe that requirement could disappear one day. So I just posed that question first. And then the second question, Michelle also raised, I thought, a really good point about perhaps in subsection C, we should specify that families have the opportunity to make various corrections during assessment versus, like you said, before it's too late, frankly. And so I just want to get clarification for that as we're trying to craft these recommendations and what the group thinks about that as well. Because we, like CPO, needs to be able to draft this with some specificity in order to capture the task force general, feelings about this.
Thank you, Stephanie. So I think starting with dot point C, and the added language about the reality that this information would be confirmed or corrected if the report is assigned for assessment, so that there is actually follow-up with the family directly versus those that are screened out where there wouldn't be another follow-up opportunity. So adding that assessment piece. Any strong objections to that? If so, use any of your reaction. Bless you, Trace. Okay, so it sounds like folks are comfortable with adding that clarifier for dot point C. And then for D, this subsection D, whether and maybe this can come through in the vote. I know that there was a question about process for the vote and whether folks would be able to vote on the subsections within a recommendation or falling under a directive, or if they'd have to sort of vote on the set of recommendations under a directive. Process question, I think, for you, Trace.
Say it one more time. I want to make sure I'm understanding.
Yeah, so Stephanie wanted clarification for D and whether or not we needed to include this as a specific recommendation for changing the law because it is a current practice. And I'm wondering if that question needs to be answered today or if it could be answered when folks vote on the slate of recommendations.
Yeah, I think that's a slate of recommendations piece. We could break it out as its own piece.
Okay. Thank you, Trace.
Yep.
Ida?
Not to belabor this point, but I wonder too if there's some benefit to having it in here related to the mandated reporter and really talking about that relationship, whereas the rules are that I think refer to enhanced screening are very much referred to how the county department takes that report. I think communicating to mandatory reporters that strengths are a part of this is a good justification to call it out. So that's my quick vote and word of affirmation for subsection B.
Awesome. Thank you, Ida. Which I think actually is a good transition into starting to think about, albeit not specifically in Directive 17, but sort of shifting to like the training piece. Because we know that there is a complementary component to this that's about ensuring that reporters know what's going to be asked of them and what we would want to elicit from them when they're making a report. So I'm going to move us on to Directive 17, and I'm hoping that we can take at least these next couple here fairly quickly. Directive 17 is about standardized training regarding the county department's process to determine which reports meet the threshold for assessment and investigation. Opening the floor for any kind of reflections, comments on ways to refine this recommendation under here. Any questions around the nuance here? Opening the floor.
Hi, this is Yolanda. So I still remain concerned about, I think maybe sort of the vagueness or the unintended consequence. It's important. I understand there's a value and an effort in gathering as much demographic information to better understand the population that is within our child welfare system. I remain concerned, though, that when that information is gathered from a mandatory reporter or any reporter and entered then into the database system as if it's
You cut out, Yolanda.
and you have a lot of
You cut out
people
for us.
who have
Yolanda, sorry, you cut out like in the middle.
oh, sorry. Can you hear me okay now?
Yes.
Okay. I just remain concerned that demographic information will be used to label a family that's incorrectly misidentified from the point of the reporter. And if the family never has an assessment, they would never have the opportunity to correct that information. So I don't know if there's some clarity that can be added. Like it could be important to gather the information at the point of the hotline call, not label it though in the system until the family has a chance to review and confirm or review and and self-identify. So I don't know if there's a way to clarify that in the language, because what I worry about, as Michelle Dossi said, there 2/3 of the reports don't get assigned to a caseworker for assessment. So if you imagine having somebody that you may or may not know label you with all of the demographic categories that have been listed there, and that gets put into a client record, and you may never know that you have that client record, and you may never have the chance to correct the information. So I don't know if people feel as strongly as I do about making sure that we have both the opportunity to gather as much information at the point of hotline as possible, and yet not use that information against a family to label them unless they have the opportunity to opt in to clarifying and self-identification. Because the way I read this right now is that the hotline call taker would be asking all of this information. It would go into the client record, and then that's what becomes the tricky part, is that it goes into the client record as if it was fact. And there's no way currently in the client records to differentiate between whether the family self-identified those labels or those categories of demographic information, or if they were labeled by somebody else who may or may not have known and may have just simply guessed.
Thank you. And just to make sure that that we're all tracking, you went back to Directive 16. That's in reference to Directive 16.
Yes, I'm sorry. I know you were trying to move on, and I was trying to come off mute because I'm in a place that's not my usual place. So I was like, sorry, I couldn't get off mute fast enough. So thank you for letting me go back.
Yeah, no problem. And then so I see Donna, Stephanie, and Leanne all have your hands up. Are you commenting back to 16, or are we still on 17? Okay, awesome. Thank you. Donna.
So I just want to just make a under the note, so please note the training is also the subject of Directive 3, and it talks about the different types of training. Not to put us back, but I think one of the disconnects that addresses what we're talking about here about mislabeling is we don't have any training on respectful inquiry, right? Like workers are not trained to even inquire about race, ethnicity, and other demographic identifiers in a way that doesn't feel intrusive. So I would love to see how we get that training in addition to implicit bias training, because it's different and it's necessary for us to be able to get this right as a system.
Awesome. Thank you, Donna. Leanne?
Sorry, I think Donna's comment was about Directive 17, and I was going back to Directive 16. So sorry to have us bouncing around. But this was just something I was thinking of while Yolanda was talking, and it's not really a response, but kind of just an additional question, which is on 16A, the information that we're talking about gathering here is just with respect to the child, not necessarily the family or the people who are being, accused as being responsible for the abuse or neglect. So I just kind of wanted to clarify if that was our intent, or if there needs to be also demographic information, if we want that same information to be collected about the family, because those could differ in certain scenarios. And if the family is being given the opportunity to confirm or correct that information, are they able to correct information? Are we talking about information about the child or about the family? So like I'm, envisioning a scenario where maybe a child has stated their gender identity, and then a parent who, maybe part of the story is that the parent is non-confirming of that child's identity, and then is that parent going to be able to like change that? I mean, that's just like one scenario that I'm thinking of. I just think that it needs to be clarified whether the person reporting is reporting that information about just the child or also the family if they have that information.
The directive is focused on the child. And so our discussion centered primarily around the child and the characteristics or personal information that gets collected from the purview of the child. But also noting your point about, some of the personal information or characteristics of the child may be misperceived, right? Or listen, whatever the thing is, right? Like parents might disagree with how how the child self-identifies. And so I take that point. Stephanie, you had your hand up and then put it down.
Yeah, I just, yeah, it kind of goes back to the conversation on 16. Sorry, Doris, but it's a broader thought, and that is this. As we are going through these recommendations, we are certainly taking notes on sort of the nuances, right? The comments that are being made about these proposed recommendations. And I guess I just want to clarify that so many of these details would go into the actual drafting of legislation versus the recommendation. So I just wanted to let people know that, well, we will certainly note, right, that there's additional details that must be considered, that the recommendation itself, as we'll be putting it forth to you, will be broader, like how, for example, section D reads, that we need to put in family strengths into that information, and additional details would have to be thought through regarding time, place, distance, whatever the requirements are. So I just wanted to point that out to people, because thank you for the comments and keep them coming. We will definitely document them. But if they don't make it into this specific language, it's because we aren't drafting the statutory provision today. So I just wanted to clarify that, because I don't want anyone to be discouraged. If for some reason you're like, we mentioned this language and it didn't make it in, just because there's so much language being proposed right now, that it would be impossible to create a recommendation that would suit everybody's particular concerns.
Thank you, Stephanie. And I think, sort of adding to that point, that there's also going to be the report that's wrapped around these recommendations, that will also be an opportunity to include some of that nuance. All right, any other thoughts around Directive 17? I want to hopefully get us through 19 before we take a break so that we can then come back up. But no pressure. All right, moving on to Directive 18, which speaks to the benefits of an electronic reporting platform for the state. And opening the floor for any comments, considerations around the specific directive and the recommendation as it is currently drafted. Margaret?
I'm happy to be told that this is not the appropriate place to raise this. Well, happy is a strong word, but the expression equal access in the third sentence, I believe that might really have no teeth if we don't recommend a fiscal note, because I've worked with 844 Code for Kids enough to know that they need some resources in order to be able to promote access. And I'm wondering if we could make recommendations regarding requiring that awareness about this training or the online platform be promoted on all Child Welfare Department websites or websites that address at-risk adults. So that's just something that was going through my head when I was looking at this. We can give lip service to equal access, but it's going to take some money.
Thank you. Michelle Murphy?
Yeah, for what it's worth, and I will continue to say this probably isn't the right place. I think the report is remarkably light on resources and an emphasis on the need for resources at every level of the system. So maybe there's going to be some overarching language at the front end, but that's a big miss, I think, if I'm reading it all correctly. I'm wondering about the second sentence and what we really mean by considering the differences in staffing and resource levels across counties. Thanks, Trace. I'm not sure what that's referring to.
Michelle, did you raise your hand to respond?
Yeah.
Okay.
So it's referring to that if it is, if counties are required to manage the online reporting, not all counties have, I mean, the statute, it requires us to review those reports immediately and make decisions immediately. And frankly, all 64 counties don't have resources in place to be watching an inbox for those online reports to be coming in. And so if it's not managed at the state level through the statewide hotline, there has to be consideration about those resources.
I would love to be able to make that point more clearly, or maybe Stephanie, when you're drafting, you can do that, because that's not clear to me there, because you're essentially saying the counties can't take this on.
Yeah, I mean, I can speak only on behalf of Arapahoe. We take 30,000 calls a year and have 17 screeners, and there's no extra staff to be and we're running 24/7 in Arapahoe, in-house 24/7, not using the state. There's no capacity to start handling an online reporting for them.
Yeah, I'm not questioning the lack of capacity. I just want us to get clear that we're not suggesting this be put on the counties. If you all can't handle it, I'm pretty sure our rural folks are, while the number of reports will be smaller, the staff sizes are.
Yeah,
smaller.
Yeah.
Thank
Okay.
you.
Thank you.
All right, are we ready to go on to 19? All right, so Directive 19 focuses on a process for inter and intra-agency communications, confirming receipt of reports, and in some circumstances, sharing the outcome of reports for certain mandatory reporters.
I had a comment on 18.
Oh, sorry.
That's okay. I was just waiting for a lull. I was under the impression that in 18 or in that directive, we were going to talk about that online system providing resources and kind of screening out. And I don't really see that name there. Did we put that in a different directive, the goal of the electronic reporting platform? Or is that in the side document?
Were you thinking about so if because, you know, conversations get convoluted. So if the issue is not really about child abuse or neglect, having some other options for reporters through that same mechanism to refer to like community-based services. Is that what you're thinking, Sam?
Yeah, that was the conversation we had, was one of the primary goals of this was to screen out and to give people practical resources. So I guess my concern is I don't want us to create an online platform that's doing the exact same thing a caller would do. That's just taking a report. That wasn't the purpose. The purpose was to be able to allow people to learn and get information that would decrease the likelihood of it ending in an actual final report.
Thank you, Sam. Yeah, that was some of our conversation. Donna?
So I just have a question about the last sentence, where it says the state must monitor for any impact on disproportionality at least annually. Are we only wanting to look at disproportionality, or are we interested in disparities as well? And maybe that's not where this goes, but disproportionality is just over or under representation. Do we want to know about outcomes at all, or are we just concerned about who's getting reported or not getting reported?
We did talk about the need to make sure that we're not over assigning or under assigning referrals online versus those in person.
Uh-huh.
So I do
Okay.
agree with you about that.
Yeah, I mean, disproportionality only tells part of the story. So, you know, I don't know if we want to wordsmith that sentence and add disparities as well, because those are different concepts. So just wanted to throw that out there.
Awesome. Thank you, Donna. Any other ideas in helping to refine the recommendation as it relates to Directive 18? All right, moving to Directive 19, a process again for inter and intra-agency communications, et cetera, et cetera. Any feedback on the set of recommendations here? Michelle?
Just a quick one. The state already has a template for MOUs between law enforcement and county departments of human services, so I think that that's not necessary. Yolanda can decide if she agrees with me or not.
Thank you. We did actually talk about the template. Margaret?
Just a process question with respect to the simplified explanations of confidentiality laws and regulations. Would it be assumed that this is something that would go through the AG's office? Or, I mean, because of the relationship with the State Department and it's legal, I'm just wondering who's going to decide that these confidentiality laws and regulations comport with what needs to be comported with. So that was one thing that occurred to me when I read those subparts.
Thank you.
Donna, or sorry, Doris, I'm gonna jump in real quick because I just saw Yolanda join back and I think she missed Michelle's point. Yolanda, we're looking at Directive 19, and Michelle's point in A was that there is a standard customizable template for MOUs between law enforcement agencies and county departments already. And so she just suggested striking that and kind of deferred to you on if that was a good recommendation on that. Does that sound right to you, that there's already a standard template and we don't need to include that here?
There's a standard template that counties have the option to use, and then they can create their own if they want to. So there's like an example template that they can use as a resource. So I would support striking that, yes.
Okay, thank you. Sorry, Doris, go ahead.
No, you're good. I thought we did talk about the potential of sort of replicating that approach with some other partners, so that there were templates for other partners outside of law enforcement. But I may be misremembering.
Like taking that as the example of, and then replicating that for other interagency relationships.
Yes. Yep.
You're correct about that. We did talk about that.
Yep, we did.
Of what caseworkers are trained to around the confidentiality laws. But then the struggle that we have of they overuse that as a reason not to communicate with community partners. And there is not an ability for us to share. We talked about, and I'm thinking of a conversation with Kevin about if you call to make a report, if Kevin makes a report and Stephanie makes a report, I can't tell Stephanie that Kevin made a report, even though their reports are identical, that there was this issue about not being able to share information, even just basic information.
So then would the language here be more about uplifting the standardized template that exists already as an example of what to replicate? Like we're using that as the example.
Yeah, and then I think we would also probably have to add some language around the appropriate kinds of entities
Mhm.
between whom an interagency MOU would be appropriate.
Yeah, so like a for example piece. Okay. All right. I think that point's clear then.
Awesome. Any other feedback on Directive 19?
I just have one more, in reference to B, where it's talking about the standardized letter. I do think that the letter should also have the ability to have a customizable field, one field within that letter to add information. So just sending a letter to reporting parties saying the referral's been screened out. And it won't be, we may, Arapahoe County may choose to refer it to preventative services, where another county who doesn't have that wouldn't have that opportunity. So I just would like to have some sort of a customizable field to go with it. I don't know if it needs to be said here, but based on the way I read it, I thought it could be helpful.
Thank you, Michelle D. Michelle Murphy?
I was just wondering about the last bullet around information about alternative resources and support services for families. Is the thought that the reporter is then gonna work with the family to provide that access? Or to get them those services or share that? Wouldn't that happen with the referring agency?
Can you say that again, Michelle?
So if a teacher makes a report and then they're getting information about other supports for the family, is the thought then that it's the teacher, the reporter, who's gonna get the family access, or wouldn't the DHS or the law enforcement who's already working with the family around this, and I would think providing those services do that? I'm just wondering the intent of giving that information to the reporter.
Well, in this instance, for that last bullet, this is for cases that are screened out. And so the letter going back to the reporter is that, this is what happened with this report, and here are some additional resources. Because we learned early on in this process that most of the time reporters have concerns about the family, and they want the family to be connected to services and supports, including when it doesn't meet the threshold for child abuse and neglect. And so this is providing additional options should the reporter want to share those with the family outside of reporting to the child abuse and neglect hotline.
But you're not suggesting that the reporter is the only one sharing that with the family, are you?
Well, there wouldn't be any other follow-up in those instances where the case is screened out. Like a caseworker wouldn't contact the family to say that we received this referral and it was screened out. There would be no contact with the family.
Oh. Okay. It just seems odd to put that on a school teacher and not a caseworker that decided the family's probably needs more resources. But they're short of this. That's part of the problem, is they're not getting resources and then they're getting referred.
But there
So
are-
that just seems, I don't want to, if that's what this group thinks makes sense, I don't want to revisit a conversation we had months, maybe years ago, but that seems
She
like
said maybe years ago.
yeah.
Fair.
It seems like it's an uncomfortable outcome for my constituency, but we'll unpack it, I guess.
There is no caseworker assigned. I think that's so on a referral that's screened out, the department, it puts it on file or keeps it on file and there's no further involvement. There's no one other than the reporting party to say, hey, here's some additional resources. So if a school calls and says the child is only eating peanut butter and jelly for breakfast, lunch, and dinner, they don't have enough food. That's not a child welfare or child protection I'm involved in. The hope would be that the teacher would connect with the family and say, here's some additional resources that sound like this might be helpful, or to call the family and say, how can I help you? Sounds like you might be struggling. What do you need? And here's some resources that I was able to gather for you.
But that helps kind of normalize it or land it for me. That makes some sense. Thanks.
Thank you. Jill?
Yeah, I just wanted to say, people don't want to get a call from a caseworker or hotline worker for resources unsolicited. If the family didn't ask for that resource, I don't think it's fair that they get a call from a child protective agency, especially since we're still building an agency that we want people to trust. So that could be a lot of fear of getting that phone call, and it isn't always easy to explain what it means to be screened in or screened out. So I think it is on us as community members, as social workers, teachers, hospital social workers, advocates, like we got to stick in there with the families. And if we have an opportunity to offer them a resource, we got to stick in there and do it, even when it's like uncomfortable.
And I think that also comes back to Donna's earlier point around training, like building skills to engage more effectively with families around that respectful inquiry, not just to elicit information, but also to have a conversation. And so like, you're not just sort of, in a way, just going behind families' backs and just sending it all to the child abuse or neglect hotline, and then calling it done. That, concern about a family requires actual engagement with the family. Jennifer, and then I'm hoping we can go back up to 7 and 11. Jennifer?
Yeah, just hearing this conversation is making me think about, as I often bring up, the long list of mandatory reporters and how many of those folks may have one contact with this family, make a report because they are required to, and have no further involvement with the family. So while I think I like this idea in theory, I'm just not sure it is going to have the impact that we would like it to in a lot of situations. A mandatory reporter might be a doctor in an emergency room, might be a veterinarian, could be any number of our random list of reporters that don't have follow-up contact with the family.
Point taken, Jen. Thank you. All right. We have almost landed the plane that we were building along the way. Trace, I'm going to hand it over to you just to see, do we want to go ahead and take like a 5-minute break, and then I'm handing it to you, and then I'm offering this.
Yeah.
Take a 5-minute break. I know that we're a little bit past where we wanted to be at this point. We'll take a 5-minute break so folks can get up, stretch, go to the bathroom, whatever, and then we'll come back to 7 and 11.
Yeah, 5-minute break. It might be a couple minutes longer. Just bear with us if so. We'll see y'all back in just a few. And Stephanie and Doris, I'm throwing us into a breakout room.
Awesome.
Y'all are gonna need to manually join. All right, y'all, we're back. So please, I'm not gonna take more time to export this as a PDF. Just don't make any edits in here. I can see if you do. I'm going to share this document where we are revising this. This is directives 7 and 11. Let's go to 11 first because I think that's more straightforward. So get out of the document you were in because we have changed the way that it is written. And get into the document that I just dropped in here. And go to Directive 11. We had to remove some language and put it, there's nothing missing from what you originally read. We just put it up in 7. So we'll get to 7 in a minute. Read 11 as it's written. We'll give you, I think, just 1 minute. And then let's open it up for discussion. All right. Jump in. If you have any feedback or clarifications, I do think, we're asking a couple of key questions down there. Those might not be the right key questions, but those are the ones that we kind of are curious about on our side. Jessica, go ahead, and then Michelle.
Yeah, so just going straight to the key questions on 11. How are we defining sexual assault? If we want to give, again, kind of referencing, right, or remembering that the drafters can kind of go with this. But I do think in terms of context of what we mean, right, it's important to define it. There are, 4 or 5 definitions of sexual offense or unlawful sexual behavior in the statutes. Throwing it out there, but interested in Kevin's ideas and other folks. I don't know if 18-1.3-1003, which is the kind of reference to sex offenses, has a reference to sex offense, and that covers sexual assault, felony unlawful sexual contact, sexual assault in a child. It refers to some old statutes too, so I'm skipping over those. Sexual assault on a child by one in a position of trust, sexual assault on a client by a psychotherapist, enticement of a child, incest, aggravated incest, patronizing a prostituted child, internet luring of a child, internet sexual exploitation of a child, and unlawful sexual conduct by a peace officer. I don't know. I mean, that one to me is kind of maybe the most, to me, we don't want to reference just sexual assault alone, right? Because that really will only cover one statute. If we are going to direct them to a statutory reference for sexual assault, that will only cover a limited amount of activity. So, and maybe this is more something we can figure out honestly with drafting when it comes to that, to be honest. But that would be my kind of first thought is 18-1.3-1003 if you wanted to refer to one. The other sort of definitions are much broader and include that exist in statute for sexual offenses or unlawful sexual behavior, include a lot more like human trafficking, pandering of a child, pimping a child, prostituting a child, things like that. So I don't know if that's the really intent of this, but so that's why I kind of go towards this one, because I think it's a little bit more limited to what your typical sexual assault that you think of. And then also when it comes to child, is that the other? Do we want to define, how are we defining child or youth? That's an interesting one too. right? Because like for the most part, criminal law, I'm just giving my criminal law perspective, but I know that there's other definitions elsewhere. Criminal law is going to cover sometimes under 15, sometimes under 16, sometimes under 18. So it's really interesting, but I guess my perspective is that this should be, if we're going to delay the mandatory reporting of incidents involving children or youth, that we should, the bottom should be 15 or older. I don't think 12 is appropriate, you know, if a 12 or 13-year-old goes to a mandatory reporter for dating violence or sexual assault. In my opinion, professionally and personally, I don't think that that's I don't think that's appropriate to delay it at that point. I think it causes a lot more concern. So my suggestion would be 15 or older. That's me. Thank you.
Thanks, Jessica. And I think your questions around which statute and whatnot are also appropriate here as we look at like the specific language approving feasibility piece. So I think we can go back and look at that too and just see what makes most sense given all the feedback. But I think that's clear and appreciate the recommendation there. Michelle and then Jennifer.
Hear me say that I understand and support the intent behind this and directive 7, but I think it applies to both. My feedback is going to apply to both. That when we're specifically talking about a child who is a victim and we extend the amount of time that a reporting party has, that people will take this literally and not use what we hope would be common sense, but that they may be delaying the ability to gather evidence, you know, getting a child medical care, all of that. I understand that we think that people will do that, but I think people will take this literally, that they don't have to do anything about it until they secure the safety of a child. And how can we ensure that kids are not remaining in an environment that is dangerous to them during that 72 hours? And so I was trying to think about a way that I would want it written if I'm trying to honor what the intent is behind this, to give people the extended time, that maybe we could say something like that, you know, the person delaying the report will ensure the safety of a child, or that, you know, medical needs are met or something. I don't know. I know many more of you are experts around this than I am. It just makes me nervous about, you know, if a child makes a disclosure and they're not safe, or the reporting party does not know that they're safe, and they're continuing to send them back into an environment, even for those next 72 hours where they have access to their perpetrator, in addition to then the potential loss of evidence.
So a clarification of that would just get more clear around why the intent behind the delay here would kind of suffice. I mean, we need to obviously do some wordsmithing, and I don't think we need to do that right this minute, but we can do that on our end, Michelle. So really what I'm hearing from you is just that you're wanting to better capture the intent here, so that someone doesn't just read this and say, okay, I don't need to, I don't have to, and I shouldn't until 72 hours. It's more that we want to understand, we want folks to understand the why behind that delay, if it's
Why, in the hope, yeah, that they're getting them some, you know, they're working to achieve safety for the child.
Sure.
I don't know.
Yep. Yep. I gotcha. Thanks for that. Jennifer, then Chris.
So I agree with Michelle. I think the intent here is missing, and I think this is way too broad and does not capture what I thought we were trying to accomplish here. There's an autonomy piece for teenagers, I will say, I guess, that we were trying to get at. That if a 15-year-old talks to someone who is a mandatory reporter, goes to get some help, goes to a rape crisis center to talk to a therapist and get some help, that has to be reported. They may not want it reported. They may just want to get some help. And so all of the conversations about autonomy we had about adults that are about Directive 7 come up here in teen dating violence and certain sexual assaults. And to Jessica's point, like, sexual assaults are broad and there's a lot of stuff there. So I don't know if we want to focus on intrafamilial things or an age or something, but really one of my priorities here is that we ensure that teens have access to support and help without their confidentiality being breached, that they're not discouraged from getting help because their confidentiality is going to be breached and either the department or law enforcement is going to be involved.
Jennifer, can I just jump in? And I'm just looking at our time. I just want to make sure, would it be helpful if we broke this recommendation out as it relates to as it relates to dating violence and as it relates to sexual assault as to, like, knowing that there could be overlap there, that knowing that specifically a recommendation around dating violence in the sense of peer to peer, that there might be something specific to say there around the autonomy of a teenager versus the difference in a sexual assault, regardless of, you know.
I think it's more complicated than that, Trace, but I do think that could be a place that we could.
Well,
start.
yeah,
And-
of
and I
course
guess
it's
my
more
last-
complicated, but that's again putting us back in the position of the drafters being able to suss out some of that nuance. And here we're just trying to clarify that in the instances of dating violence versus sexual assault, right? That those two
Yeah.
could be two separate.
And I don't actually see any point in the extension of time in this case. I don't see the value in that here, but that's my 2 cents.
Yeah, I think that came up because it was discussed in the group as another tool for like safety and consideration around the youth piece, but we can go back and make sure that we captured that right. But I think the delineation between the two might be helpful here, to kind of get at what folks are, and some of those nuances that were named. Chris, go ahead and jump in, and then I'm going to move us over to 7 if there's not any additional.
I just, and take this for what it's worth. I've been having a lot of issues in a lot of the things that I testify in the courtroom is about a child's right to consent at 12 years old for their mental health without the parent. And I think that we should be cognizant that putting different age limits than what the state has already put in for mental health or for what this is a mental health issue as well when we're talking reporting. And so I really think that from a child's standpoint, giving them the advocacy at 12 years old should match what we're doing from the mental health standard of the state already, based on the fact, yes, there may also be physical health issues that needs to be addressed with a parent. I get that piece of it. But at what point do we still need to advocate for that child who has their right to their own mental health in what may be going on in this? So I would just suggest that we stay consistent with the language that's already in place, because I feel like we're going to open more Pandora's box and continuing to have different languages for every agency, different age levels. And that's just confusing to the reporter or the other people who are involved in the interagencies that are working with that child. So that's my 2 cents on that.
Thanks for that, Chris. Okay, I appreciate that. Clearly, we need to do some clarity there around the intent behind, and I think the breakout piece that I was suggesting will potentially be helpful there around just how we're talking about this separately. So we will take a stab at that. I want to move us over to 7. This is a big one, and there's some clarification here that I want that we're gonna draw out here in a minute, as far as, are we getting this right with how we want to write this out, and the nuances. So just stick with us for a little bit. But we'll just ask folks to limit their comments to specifically what's going to make this feasible, what's going to make this clear, and that we're not debating the issue at this point. We are just, how can we get as clear as possible as far as what this is saying? So just want to clarify that with the time we have remaining. So if you go back up to 7, I'm going to give us, I know that do folks need more time to read this? Have folks read the rewrite of this? Okay, let me give you, we just moved the order of things around. I'm gonna give you 3 minutes to read this, and let me know if you need any more time. I'm just looking at our time. Thanks. All right, are folks good? Okay, so I want to go through these just real quick, a couple of notes. So one is the removal of victims advocates. Two is and a definition of exactly who we're talking about here, which was a big part of the conversation. Two is, should there be no legislation to remove victims advocates, then the recommendation of the 72-hour delay about the folks that we were talking about specifically in that definition. So I just want to clarify those two things. I think the third thing here, that's the question, is if there's not folks that are captured by this definition that you still want a delay for, that would be a third recommendation. So if there are people that are not captured by this definition of victims advocates that we're still wanting a delay for, that would be a third separate recommendation. So that's just a question I have. But we'll put that on the shelf for a second. Jessica, step in with some comments and we'll go from there.
Thanks. The only thought I had referencing back to, or that I think would help be clarifying and referencing back to some of our discussions is we might want to put, right, that if a person, I think we discussed, I'm trying to find the best way to say this. We discussed that, people that fall into the definition of victims advocate under 1390 107 1K2, may also wear the hat of another mandatory reporter, right? Like licensed professional counselor, or there's a couple mental health professional, right? And so we might just want to put a clarification in there, because I think our recommendation here is remove victims advocate from 19.3.304. But we might want to, just to be clear to the legislators, put in something like, if a person, falls under another, this might be obvious, right? But if it's sometimes feels like it's not. If a person falls under another mandatory reporting definition, then they have to report under that. Does that make sense? Just trying to clarify, right? If a person has multiple roles, that they aren't they can't consider each role exempt because they're also a victim's advocate, but
yeah,
right,
I think it's a qualifier line then after definition. If if a reporter falls into, and we can give example categories of
just to try to make sure that they understand it. If they do wear multiple hats, then they have to consider each hat that they wear, I guess.
Yes.
Obviously that's not the language,
Good
but
call out, because that was part of the conversation, and so I think that makes sense on the feasibility side. Appreciate it.
Okay, thanks.
Yeah. Yep. Also, just want to name real quick, I don't see any members of the public here, but if there are any members of the public that we're hoping to provide public comment, please send me a note currently. Otherwise, we will take this meeting to the full 10 o'clock. Jennifer, then Kevin.
To Jessica's point, I just want to throw out there are people who are operating in a role as a victim advocate that maybe are a licensed professional counselor, but they're not practicing as a therapist. So it should be the role the person is in, not the title or the licensure or whatever. And that is really, really important that we're clear about that. I think that can actually be in one of our prior recommendations that we could expand upon. Not only is it that you're not on duty 24/7 as a mandatory reporter, but it is the role that you are currently operating in. For example, I'm a therapist and an attorney, and those two things conflict when it comes to confidentiality and privilege. So I think it's really important that we don't say, because you happen to be a licensed therapist and you are currently working as a victim advocate, that doesn't make you a reporter because you're both. If that makes sense.
So are you saying, can you say like two more lines about that? I just want to make sure I'm understanding. So
yeah, sure.
It's depending on how the report is made and what role you were in as that.
So yeah, it is the role the person is employed in or performing at the time, not their personal title or professional.
Yes. Okay. I got
credentials.
And I added some language, Trace, in the chat that when they're acting in the capacity of a victim's advocate versus in other roles that they may hold.
Great. Thanks, Doris.
Got it. Okay. Thank you. Any other folks here specifically around 1 and 2 as it relates to 7? Okay. I do want to ask the question, are there, as it relates to the 72 hours, are there, the 72 hours is contingent on if the first piece passes, right? If the first piece passes, then the 72-hour delay as it relates to victims advocates is kind of a moot point. However, are there folks outside of that role that you're wanting to write a third recommendation around as it relates to the 72-hour delay? Are there people outside of victims advocates that would be reporting in this kind of context? I just wanted to ask that. Is there a scenario? Maybe this isn't even a thing. I just wanted to make sure there are other folks we're not capturing when we talk just specifically in this definition that you're still wanting a 72-hour delay around. This is a question for the broader group. I think the answer is yes, as I remember the conversation, but I think this is just more of like a clarification. Are there people that don't fall in this definition that need more time? Potentially. I'm seeing a yes in the chat and I'm seeing some head shakes. Anybody want to jump in? I'm just going to leave it as a non-written thing if it's not clear where folks are landing here. So Gina, do you want to give a comment around what you're referencing?
It was just a yes to the moot point that you made earlier, not to the question you're asking.
Oh, okay. Okay. Well, then I think the answer there is no. So we will kind of clarify on these 2 points. Gina, did you want to jump in then on another point?
I didn't, other than I have no notes around the exemption, just that I think that also aligns in terms of some things with the role that we hold as advocates, especially in these types of situations in IPV.
Okay, gotcha. Thank you. I also want to clarify that we still have to vote on these, and so we are going to break out 1 and 2 as 2 different pieces for the sake of voting, because I know that there might be people that would vote no on the removal, but yes for the delay. And so if the removal weren't to pass, majority would still want to be able to put the delay in there. So when you're voting, you're going to see them as 2 separate pieces. But if the removal passes, then it would just be as written in here, which is like, if legislation is not drafted around the removal, we'd want them to consider the 72-hour delay. But I don't want to completely leave out folks that might vote for one and not the other, and then completely miss it as a whole package. So you'll see that breakout in the voting, just FYI. Okay, any other questions or comments here? Kevin?
Just a real quick question on this. I know that some of what we're doing is looking at this as we feel today. Is there any room in this for provision to revisit 5 years from now, 10 years from now, to see whether any of this is effective or useful, or if mores or morals have changed since we've done this now? Because I think it's been such a long time since we've looked at the mandatory reporting law, and it only came about because of a tragedy. And so some question of sunset or review or whatever put in here in recommendation for is it actually working or accomplishing what we hope for it to accomplish?
Yeah, I love that. And let's put a pin in that for our wrap-up meeting. I think that's actually a great question to kind of hear from you all as to how you would like to see that reflected in the report, of some sort of, recommendation, or even just narrative. We can capture the narrative around, so it wouldn't be a recommendation, a narrative around what this group would hope to see in a review or a revisit of the content, and how, we could re-engage this group or a similar group in future years. So I love that. Kevin. I think that's a great question around kind of our wrap-up meeting in November is really to look at how things landed with the final voting, to reflect just on the work done, and then also to talk about any next steps. And I think that exactly is a perfect thing to talk about as it relates to next steps and what folks would hope to see. So with that said, I appreciate everyone's work today. This was a lot to get through, and so really appreciate folks just digging in and sticking with us. Just to clarify on process, we're going to go back to the drawing board with these edits and do our best to get to where we think things are. And then the next time you will see these is in voting form. We will be voting on online just because we think we've seen that's easiest with participation across the group. So if I ping you and say we haven't gotten your votes yet, that's just because we wanted to make sure we have full participation, if at all possible. Again, if you are intending to abstain from any voting, we do ask you provide a letter, and that deadline is in your email as well, just so that any legislators or folks reading the report would understand why there might be an abstention after this level of work done here. And then we will use the November meeting to review where the votes landed, to just kind of celebrate the work that you all have done to date, and then to talk about next steps and what you all would hope to see in a group in the future like this. Michelle, you're killing me. It's 10:01. What's up?
Sorry. Can you send out the final recommendations for review and comment before we go to vote? Because there's some significant changes that we've talked about, clarifying changes, and if that makes me uncomfortable that I'm gonna have to vote no because some of the changes that we talked about, blah, blah, blah.
Yeah.
That's my request.
And
I appreciate
some of us are part of bigger networks where we're representing more than just our vote.
Yeah.
And so that I would echo that. If it's a possibility, I realize we're working against some timeframes here.
We're working against some timeframes, but I think that's a super fair request. So we will go back to the drawing board and hustle as much as we can. And I think maybe it's that we're pulling out a few of them that have the more,
Yeah.
and it's just like you're looking at 3 or 4, because obviously a lot of these are kind of ready to roll on. So I'll work with the CPO team on that, and see what we can turn around, and appreciate that request for sure. So we'll do everything we can.
Thanks.
Yeah, for sure. Okay, with 10:02, blame Michelle. But good question. Good question. All right, y'all. Appreciate you. Please pay attention to your inboxes. One way or the other, we'll get these back to you either via voting or for some additional comment, feedback, clarification pieces. And we will roll on into November and have a closeout discussion there. And thank you all for your work and attention to this. And reach out with any questions. Take care. See y'all.
Thanks, everyone.
Have a good day, everyone.